Thursdays.
Oh, I'm totally good with Thursdays. It makes a lot of sense. It makes it easy.
Yeah, because then it's like, I feel like after going to court on Monday, I'm just kind of a cunt. You know, I'm just like, fuck everything. Why am I doing this? All right, welcome to the JudgMental podcast. We are going to give an update on Shelly Santry and the motion to recuse. And then also, if you listen to our episode from 2 days ago, oftentimes we get tipped just by seeing what happens in court or people send us stuff. But I kind of did a deep dive in that case, and it's a hot mess express.
Yeah, I mean, you've showed me some of the pleadings in it, and I thought we had issues with orders that set things up for failure.
Yep.
From the judge, and then I realized that they were agreed orders, which most likely meant the judge had no hand in writing them. The attorneys actually put it together, and the judge, for some reason, signed off on it.
Yeah. And so just to back up a little bit, go back and listen to episode, I want to say 23, where we talk about the motion to recuse was filed against Judge Shelly Santry for going to a partisan campaign kickoff event for, I can't say her name right. Do you know how to say it?
I don't remember who it was, honestly, now that I think about it. I honestly don't remember.
Hirachi?
Yeah.
Oh,
that's right. Yeah.
Yeah, she's running for state rep, and the judge had her arm over Miss Hirachi. Am I saying that right? I don't want to be insulting.
Well, I'm not her, so
Okay.
What do I know?
So anyway, and the judge got very defensive. There is no order out yet about the recusal, but at the same time as the recusal, there was a motion that was to change the GAL to a parenting coordinator, which are very different, distinct roles, right?
Yep.
And a GAL literally is an attorney that is appointed to represent a child's best interest acts as an attorney.
Yes, acts as an attorney. The child is the client.
Yeah.
Now, it's distinct because you're governed by the child's best interest, and that can sometimes be in conflict with what the child wants.
Yeah.
But you have to act as an attorney. You have to follow the same rules as an attorney. You don't get to file reports or inform the court of anything differently than anyone else. You file pleadings. You present evidence in trials. You conduct, testimony with witnesses. You cross-examine other parties' witnesses. You are acting as an attorney, and because you're acting as an attorney, you can't be a pseudo judge.
Yes.
You can't be a parenting coordinator. You can't. We have. Hell, it's an old case now that says the GAL is very distinct from the advisory witness court-appointed position of an FOC. They are distinct roles in Kentucky, at least.
Well, let's back up. So I was a juvenile public defender for many years. It's the job I absolutely loved. When I represented my children that were charged with crimes or status offenses, is something we have in Kentucky, where if you were an adult, it wouldn't be a crime, but you're entitled to representation.
Mm-hmm.
I represented my juvenile children the exact same way that I would represent an adult, the exact same privilege. It was what they wanted. I was an advocate for my client. The distinction for GALs in custody actions or any of these other actions are that you have the same attorney-client privilege, everything, but your client is that child or those children's best interest.
No, that's right.
Yeah.
And so as an attorney, talk about, like, you say they're very different things when you're talking about a parenting coordinator versus an attorney. So as an attorney, let's say you represent one of the parents. What are some things that you would never be able to do as an attorney in the case representing a party?
Make binding decisions. Testify to the court.
Talk to the other party.
Yeah.
As an attorney, you don't get to speak to the other litigants outside of their attorneys, without their attorneys present.
In fact, you'd lose your license if you did it.
Yeah, that's right.
So to back up, because our audience doesn't know what happened in this agreed order yet, is that we had a attorney that's appointed to represent the children, mom's attorney, other mom's attorney, that all agreed to appoint this person as a GAL that essentially was given what?
Well, in the agreed order, I think the person is already a GAL at this point, and they're just appointing powers to the GAL. And the powers include coordinating child-related things with the attorneys. With the parties.
Mm-hmm.
It orders the parties to communicate certain things through the GAL. So in this order, you're telling litigants who are represented by an attorney to communicate directly with another attorney representing a different client. Like
It's
the
insane.
ethical rules don't allow for
it.
that. But then it also says that they are bound by the decision of the GAL. So the GAL is not only given some parenting coordinator roles, which parenting coordinators in Kentucky help make sort of, I say help, and I saw your reaction to it. The idea is that they do some micromanaging of parenting decisions that generally the court isn't well suited to handle, because you can't just keep coming in front of the judge every other day and having someone make a decision. Now, there are lots of pros and cons to it, but just as a descriptor.
Yeah.
So you're allowing an attorney, or you're not allowing, you're forcing and appointing and giving the power to an attorney who represents a party, the child, to a case, to make binding decisions on other parties.
That we don't, and we don't even know the facts that are of dispute yet. It's just basically if there are any facts or situations in dispute, this attorney can make the ultimate decision.
And it's not limited.
Yeah.
Is if this GAL says something, the parents have to do it.
Yeah.
Like, that's delegation of judicial responsibility to someone who is an attorney representing a client, which it violates a lot of rules. It's
a shit show.
You can't delegate judicial authority. You can't order people to follow the recommendations of one attorney representing one party in the case. There's so many problems with it. And
let's make it like a little bit more simple. So it would be akin to if Hugh is representing a client, dad, Christine is representing a client, mom, and we sign an agreed order that says counsel for dad can make all the decisions about anything, and mom shall go directly through counsel for dad.
Yeah.
That's
and without her attorney present, and there are huge ramifications for if a client speaks directly to an attorney for another party.
Yes.
You can be waiving all kinds of privileges that will come back to haunt you in the case.
Or saying something that's not in your interest that an attorney can protect you from.
Yeah, that's right. And that's what's being set up in this case. Basically requiring the parties to go through another party's attorney without their attorney present,
and
with communications, and then be bound by an attorney's one party, their decisions on virtually anything kid related.
Yeah. And I think the bigger problem too in this case, and we'll have to go back and look at the agreed order, but I think these parties are currently having no contact. They can't even talk to each other.
Yeah, there are just so many problems. And
all it does is make the GAL rich.
Well, initially I thought, I've seen these types of orders out of certain divisions. I've seen them challenged. I've challenged them. So I was thinking, oh no, we've got a judge who's issuing these orders and sort of delegating his or her power to another person. And it's been, there's law on this, and there's lots of reasons why you can't do this. But then I noticed that not only did the judge order it, the parties drafted it for the judge to order. So we have all of these attorneys involved and the judge all creating this mess together, and nobody raising a red flag about it, all going in and saying, this is how we want the case to be set up, and this is who we want making the decisions for our parties, and we just want to blanket waive all kind of privileges and protections. And yeah, it blew my mind when I saw that was an agreed order. And so just couldn't believe it.
Backstory about how kind of we communicate about stuff. I'm like super annoying in a lot of ways, and I'm like old school Catholic. I don't think this has anything to do. I'm talking about just I like to gamble. But every time I send him something or tell him something, I'll be like, guess who? You know what I mean? Like, guess who? Or how long was the day? Like, I'm always like, make a bet. Let's do this. And you did not guess the judge, and that's because it was an agreed order.
No, that's right. Well, no, that's right. And it's not something I would have expected out of this court. Mm-hmm. I'm shocked a little bit by that, but I did not know it was an agreed order. So I guessed incorrectly, because there was, one of our judges here in Jefferson County was really known for these types of orders and just regularly delegated. Well, there's two of them that were particularly bad about it. Three of them that did it fairly regularly, that just would delegate their power and would get reversed on it. And there were so many problems, and he would do it all the time.
And he doesn't care.
This was not one of this is not one of those divisions that I'm used to it.
And I think this is even, first off, I am torn with what happens next. So when the motion to recuse was filed, the reason it came onto my radar is because there was also a motion for a parenting coordinator. And it basically said the GAL is acting as a parenting coordinator. And then I looked up at the order and I was like, yeah, they are. And those two roles cannot be done at the same time by the same person.
No.
But I think that even goes, it's a mess. That case is a mess. I don't even want to know how much these parties have paid. But I can see now there's not a question in my mind that Shelly has to recuse, because that GAL was given an obscene amount of power and the appearance of a conflict, which I already thought existed. But it's a shit show. I think it just needs to be scrapped and everybody needs to start over.
Yeah, but that's not necessarily what happened. So, first of all, I'm interested in your opinion on how this agreed order changes the conflict, because I didn't make that connection. But starting over with another judge, you're going to start with the same order in effect. Like, recusing and it being assigned to another judge doesn't start over again. It just takes the same shit show to a different location.
I think it, one, increased the appearance of the conflict given the nature and power that this GAL has via an order. When I say start all over, I think at least that provision of the agreed order needs to be struck, because I think it really violates just basic principle. I don't think it's a void order on its face, because it's essentially illegal is not the right word. Give me the word I'm looking for.
I think that it might be. I mean, I think
Really?
I think if I were coming in on this case, one of the first things I would look at is some of the Supreme Court rulings from the Supreme Court of Kentucky to see if there's something that's so very specific about it in an interpretation of a statute that you can then tie it to a statute and say this is void on its face. I don't know. That'd be the first place I'd look. I think that's a long shot.
Yeah.
But it's so contrary
It's a
to
nightmare.
clearly established law. And then, you know, looking back on the case where people complain about the GAL acting as a parenting coordinator and needing to switch the roles, they created it. They created
Exactly.
the problem with that language. That's exactly what they did. And maybe I got to look at the timing. I wonder if the judge refused to convert the GAL over to the parenting coordinator, so they just made an agreed order which virtually did the same thing, but continued to call the person the GAL?
Which you can't do.
Which you can't do.
And then there was a response that was filed on October 6th. Today is October 9th, I think. And it basically was saying, I don't know what it was saying, to be honest, but they didn't want the judge to recuse, I don't think, and they didn't want the GAL changed, and that the costs were already cumbersome. But this is just your perfect example of a family court case that becomes incrementally a shit show, because you have these agreed orders or you have these things that you could never. It's easy to say in a mediation room, okay, just sign this or this, but like the long-term effects. And to go back to my point earlier about why I think it's a bigger deal, I think that knowing how much power this GAL has, when the parents saw the GAL with the judge, that would make a pit in your stomach.
No, I agree with that. And now I will go out on a limb and say that I think that this, like so many messes we see in family court, was created because people were trying to be creative in working to help their clients and help this family, and have created a giant mess by not following the law and following the rules. I don't think that anybody manipulated to create this situation to get a leg up or to game the system. I think it's just something that happens regularly within the system that's improper, that creates a much bigger mess, because at least what I know about the attorneys in this situation, it would shock me if someone knowingly got their client into this mess.
Oh, I don't think they did. And knowing the two main attorneys on this case, I don't think it was a knowing thing. It was improper, in my opinion.
No, I would say that. But also their argument about how the costs are already so high. Yeah, I get that. You want to keep the same person involved so you don't have to get a new professional and get them up to speed. I get it. But that ship has sailed. Like, you've now created this problem where you can't. This person has worn too many hats improperly. In my opinion, they can't continue on this, and you have to get someone else, and you have to start clean. My point was just that by one judge recusing and kicking it down the hallway to another doesn't start clean. You still have these same exact problems. You just have a new judge who comes into it with fresh eyes, looking at this and probably thinking, "Oh crap, this is a mess."
Well, and I think too, you know, that one of the things, once this motion to recuse the judge, it was filed, and I don't understand why. Like, you talked about this on the last episode when we talked about the recusal, is like, judges, the appearance of a conflict is enough. But the GAL that's appointed, that's running for office, should have been like, one, I can't be a GAL and a parenting coordinator. The fact that the GAL put herself in that role fucking terrifies me. That shows that you don't have enough sense to come in out of the ring.
Yeah, but we see that all the time.
I've never seen it.
Oh, I see. Oh, well, I practiced before the FOC and the GAL roles were actually
Yeah.
separate, and they were combined like they are in so many other states, which I don't understand. So I'm kind of used to that. And
No,
I
but
know that a lot of the people that were FOCs or GALs before that split of the roles still exercise them interchangeably,
yeah.
improperly.
But no, what I mean is like her signing that agreed order, appointing her as a guardian ad litem to essentially carry out the parenting coordinator role. If she thought that she could do that ethically, that's concerning to me.
Yeah, but I also understand why. Yes, I agree. Like on its face, you should look at this and say, no,
Nope.
that can't. I mean, the same reaction I had when I read it. I'm like, wait, it says GAL.
Yeah.
Stop. You can't do these other things. But when the courts are regularly signing orders and giving people those powers to try to move cases along a little bit more and delegating a little bit more of their job over here, a little bit over here, in the in the hopes that it makes things more efficient, it doesn't, efficiency, which it's not. It creates more problems, more costs, drags things out. So it's a fallacy that it's more efficient, but efficiency doesn't doesn't change the fact that it's legally improper.
Well, not even that though. The GAL basically said by signing that order, said, I am not, I mean, you violated her duty to advocate for her client, which is the child or children's best interest, because that is a violation. Like an attorney representing mom or dad couldn't sign something like that. I mean, was there even a conversation with the child or children about what was happening? Her actual client?
Yeah, and I would also be curious to know if there was knowing waiver or
Yeah.
something by when the parties speak directly to the GAL. Like if I were ever going to allow, and there's been limited circumstances maybe where I represented someone that was in such a unique business or something that in order to move the case forward, I would allow the other attorney to come in and just, with me present,
Yeah.
ask questions of my client about the business to get a better understanding of it.
Yeah.
But there were always so many rules. You represent this person and you're going to be talking directly to my client. There's so many rules that have to be followed and boxes that had to be checked before I would allow that to
But
happen.
even if you're in the middle of it happening, you would just say, stop talking.
Yeah, exactly.
Mhm.
Like I wonder, like, did anyone even think about that? Are they just authorizing their client to talk to an attorney for another party about any number of things just so they don't have to talk to their client about it and they don't have to solve the problem?
And I think this is one of the huge, there's so many problems in family court, but just the fact that you had lawyers that did objectively, in my opinion, make the situation for this family worse. And to go back to my point is once that recusal was filed, I think if the GAL had any sense at all, she would have just said, you know what? You've got two parents that feel a certain kind, or at least one of the parents that feel a certain kind of way about me. I've got a duty to represent my client or clients, and I'm making decisions that are binding, like in a judge position. This is a mess. I need to just step out. I need to bow out, not make any more money off this family.
But instead, the GAL signed off on the agreed order and
still argued that the judge shouldn't have to recuse. The GAL said on the record, Your Honor's not going to, and I'm paraphrasing here, Your Honor's not going to endorse me, which I thought, like we talked about, was even bigger because she's speaking for the judge. It's just an absolute mess. And I wonder what would happen if this person does win the race. I mean, how are they going to try to legislate more power to family court, which is concerning personally.
that's a much deeper topic that I had not considered. And now,
Maybe
now I'm
nightmares.
concerned. Yeah. Thanks for that.
Oh, my bad. I know I'm always like the Debbie Downer riling everybody up. Although every once in a while, y'all, when you see Hugh really go, I mean, I'm just like, okay.
Yeah, it's bad.
It's hysterical.
Yeah.
Judge-y.com. When this airs, the leaves are going to be changing. Get all up in the comments. Kentucky Christine, Judging the Judges. Go to our YouTube, for crying out loud, and follow us on YouTube before I have a stroke.
Yes. Before she has a stroke.
Bye.
Absolutely. Peace.